And welcome everybody to this online event, this panel discussion and press briefing that epicenter.works is hosting today on May 8th, 2025 about the impact of spyware on civil society and liberal democracies. We are very happy that we can bring you this online discussion with our great panelists. We have Andreu from the Eynde from Catalonia, Spain, criminal lawyer who also has personal experience with spyware. We have Tanya Fachathaler from the policy team of epicenter.works that will bring the Austrian context with the proposed legislation that is currently under consultation. Walter Strobel is a representative and a lawyer from Presseclub Concordia, a journalist association, and René Meyerhofer, professor at the Johannes Kepler University, where he heads the Institute for Network and Security, will talk about the technical side of things. We will record this discussion, and the recording will be made available online afterwards. As you can hear, the majority of the discussion will be in English, but you are free to ask questions in German and we'll then translate. And yeah, without further ado, I would give the word to Andreu to start us off.
Okay, thank you, Thomas. Guten Tag zusammen. Ich muss Englisch sprechen, da ich mein Schuldeutsch fast ganz vergessen habe. Entschuldigung. Well, I want to thank my colleagues at Epicenter for inviting me. I will be as direct as possible of this critical issue and use my 10 minutes. Okay, you may know that Spain is among the European states where Citizen Lab and Amnesty International uncovered a large-scale espionage scheme involving Pegasus spyware. Just 2 days ago, we learned that Spain was NSO second client after Mexico, having used Pegasus, at least from like a decade ago, to hack the Catalan president at least 35 times. Pegasus, reportedly deployed by Spanish intelligence, has targeted at least 65 Catalan victims, politicians, journalists, human rights defenders, including every Catalan president since 2014, their families and their staff. It has also reached members of the European Parliament that have immunity and lawyers like me. As a criminal lawyer and cybercrime professor with no political ties at all, I was nonetheless subjected to Pegasus surveillance during the COVID lockdown. At that time, I had all my professional meetings online because I was representing jailed Catalan politicians they were convicted for the independence referendum of 2017. Since then, I have filed several criminal complaints against Spain's secret services and NSO Group for illegal espionage and hacking. Probably you know that Pegasus is the most invasive tool ever designed to violate human rights. It uses zero-day exploits and zero-click infections, so the victim does not have to interact with the spyware. And it has advanced stealth features, so it's untraceable. Modern spyware is a cyber weapon and should be permanently banned until strict human rights compliance and independent oversight can be guaranteed, which is something really difficult, and I don't know if we will see that. Because how can citizens control a cyber weapon that we don't even fully understand and it's untraceable? Spyware from private contractors like NSO Group thrives in secrecy. Neither the public nor the judiciary fully understands its capabilities, nor we can detect it. Such deeply invasive tools inevitably lead to abuse, harming innocent people. In this case, like me, we are collateral victims, an idea echoed by the Austrian Constitutional Court ruling, as you know. Something that's undetectable will always end up in abuse. Catalan victims have sought answers from multiple institutions, Spain's Data Protection Agency, the Ombudsman, ministries, courts, but no authority has confirmed even having Pegasus. And we don't know any rules or protocols governing its use. Our limited knowledge comes solely from expert reports identifying Pegasus traces, investigative journalism, and findings from the PEGA committee in the European Parliament and other international efforts. Modern spyware today is uncontrollable and must be banned. A key issue is the misuse of secrecy laws in Spain to block access to information, hinder legal redress, and evade surveillance oversight. In Spain, spyware used by intelligence agencies faces no pre or post authorization controls. Officials from the National Intelligence Center repeatedly rely on official secrecy and national security to avoid disclosure. Despite some progress, because we've managed to indict the former director of the intelligence services in 3 criminal cases, the government still relies on secrecy laws to obstruct transparency. Only in one case of the former Catalan president, Mr. Pere Aragonès, did the Spanish Council of Ministers authorize a partial, heavily restricted disclosure. It revealed a Pegasus surveillance of the president over 9 months, and we could see the judicial warrants. It's the only case where we could see a judicial warrant authorizing that, which was heavily redacted. You know, it's all blacked out. And then when we went to the legal reasoning of the ruling, it was 3 lines that were even blacked out. So there is no legal reasoning behind the use of Pegasus in intelligence in Spain. In short, intelligence services in Spain often act without warrants, meaning like fully illegal, and in other times with arbitrary ones. We are facing serious obstacles in our criminal investigations. In all Pegasus criminal proceedings, all evidence has been uncovered solely by victims. We have to do all the work because no judges, no prosecutors are helping us in discovering things. Spanish courts routinely reject our private expert report, the computer forensic reports, insisting that we, the victims, we have to hand over again our phones to the police, which was probably the suspect at the first time. But they say, okay, we have to perform like an expert witness report on your phone, so hand it over again. So all my private and professional data, I have to hand it over again to the police. In my case, I've really struggled and I had to challenge the judicial warrant. And finally, in an appeal, I managed to convince the Court of Appeal that as a criminal lawyer, as a lawyer, I could protect my professional data, my privileged data, and rely only on my private expert witness report. But this doesn't happen in all other cases. And my own legal case, now managed by Iridia Center for Human Rights in Barcelona, by its strategic litigation team, has exposed that NSO Group's complex corporate structure has lots of subsidiaries in Luxembourg with frequent management changes. We recently obtained authorization from the Barcelona Court of Appeal to extend proceedings against NSO Group and its directors. Yet success depends on Luxembourg's cooperation in executing multiple European investigation orders. Again, victims bear not only the damages, which are devastating, but the full burden of uncovering the truth and seeking justice with minimal support from Spanish authorities. I'm trying to make a wrap-up of my experience in all these criminal cases. In Spain, the Pegasus scandal underscores severe violations of fundamental rights and the rule of law, in line with the Austrian Constitutional Court's main concerns. We've seen a massive abuse targeting many individuals. I think it's the largest espionage scheme in whole Europe. There are no exclusion rules for privileged professionals that could be protected from espionage. There's no guarantee that spyware is deployed only to prevent crimes. In fact, we don't know a single case where Pegasus has been used to solve a crime. But we know lots. All the other cases are targeting human rights defender, lawyers, dissidents, politicians. And finally, we've seen that there's an unlimited, unregulated use with no transparency or oversight and no possibility of monitoring spyware use. So I would like to finish saying that we urgently need countries like Austria to sustain open discussions like this one that we are having, and strong resistance to spyware regulation to prioritize human rights. So thank you, and I'm open to any question or clarification that you may have. Thanks, Thomas.
Thank you, Andreu. And then we go straight to Tanya.
Well, thank you very much. After these, well, very impressive and also shocking words that we heard from someone who is directly affected by the use or misuse of spyware, well, it's pretty challenging to follow up. But basically, what we've just heard sums it up pretty well. In Austria, there's almost been a decade now of attempts by the government to introduce legislation for spyware. So far, we are the only country in Europe that does not have a legal basis for the use of government spyware. The organization epicenter.works, we've been a major force behind limiting and toppling all the efforts that have so far been on the way, and we've succeeded several times. A major highlight, as has already been mentioned, was the 2019 decision by the Austrian Constitutional Court, which highlighted the paramount importance of privacy and pointed out the dangers and the effects that the use of spyware has exactly on those rights, privacy, data protection, and many others. So we thought that issue was settled, but in the last years, in particular last year in the autumn and now again a few weeks ago, we've been confronted with new attempts to introduce legislation in this country. Our campaign and also the statement that we've submitted analyzing the draft laws pretty much echo what Andreas just said. The laws that we're seeing, the proposal that we see is based on the promise, a wrong promise to the population as such, arguing for an urgent need to introduce spyware in order to fight crime, in particular terrorist attempts. This was all based on, so-called offenders or people that apparently tried to commit terrorist attacks. We've seen this with the Pride Parade in 2023. We've seen this with last year's Taylor Swift concerts and so on. So the debate very much focuses around the security issue of things. And based on that security thinking alone, the call for spyware, for the introduction of spyware, came into being again. What is missing in the debate and what we are trying to add to it is a more substantiated and fact-based approach, in particular having a look at the human rights cost of things. Because as we've heard, it is not, the introduction of spyware is not something that Austria can do by itself. We neither have the capacity, nor I would say also financial means to create, to code the necessary software. We would have to buy gaps. We would have to buy security gaps from other states, maybe on the dark market, wherever, on the dark web, so as to actually be able to introduce spyware. This not only goes against the very principle of the state's obligation to keep its population safe. It is a conflict between the so-called security centered approach that the state wants to take and the protection that it has, also a legal protection that it has to keep the national infrastructure, IT security safe. I just want to flag that, for example, the NIS2 directive is one of the laws that we have not yet transposed, which also would require us by law to keep the IT security in our country safe, the IT infrastructure safe. This is not happening. Obviously, the state would invest taxpayers' money into the acquisition of security gaps in computer systems. And we all see that this is something that just doesn't add up. It just doesn't add up with the state's protection obligation. And it leads to a lot of unknown dangers that we've just heard. Untraceability is one of the things. The misuse of security gaps by other actors. The misuse also against persons like we've seen with Andreu. So people that are protected by a professional secret. We see, journalists, lawyers, other professionals you might want to think of. There are no exceptions about this also in the current law. We don't see a sufficiently strong accompanying legal protection control. We don't think that the introduction of spyware also is the least intrusive means. So far, there has not been a legal basis for the Secret Service to use the possibility to monitor unencrypted messages. Unencrypted messages were the messages that with which the last cases that were quoted by the Minister of the Interior as a need for introducing spyware were based on. So the problem that we're seeing is that we don't make use of the tools that we have at hand already, or we use less intrusive means, like, for example, monitoring unencrypted messages, but we go in full scale, wanting to use technologies based on wrong promises, and we're not aware, we're not discussing the costs that come with human rights and also for IT security. I leave it here, and I'm happy to go into more details that we've discussed in our submission.
Thank you so much, Tanja. And now we're going to go to Walter and also make a switch to German. And so, Walter, please kick us off.
Yes, thank you, Thomas. Since we're discussing a draft bill, I would prefer, for the sake of precision, to continue in German. Thank you for understanding. So, ich hoffe, ich werde nicht so technisch, aber ich versuche das ein bisschen aufzudröseln und so zu zerlegen, weil in Bezug auf das Berufsgeheimnis insgesamt und auf das Redaktionsgeheimnis, also den Schutz von journalistischen Quellen im Besonderen, fehlt mir da doch einiges in dem Entwurf. Vorauszuschicken, das Redaktionsgeheimnis in Österreich ist ja also das Recht von Journalisten als Zeugen vor Gericht oder Behörden, die Aussage über Quellen zu verweigern. Und dieses Redaktionsgeheimnis ist ja grundgelegt in der Europäischen Menschenrechtskonvention im Artikel 10, ist in Österreich aber besonders stark geregelt an sich. Wir haben nämlich in der Europäischen Menschenrechtskonvention kennen wir eine Abwägung, eine Interessenabwägung. Und das Mediengesetz, Paragraph 31, das eben dieses Redaktionsgeheimnis festlegt, das kennt keine Abwägung und wirkt absolut. Also das muss man mal mitdenken, dass wir da einen sehr, sehr hohen Standard an sich haben. Von dem sollten wir meines Erachtens nicht abrücken. Und in dem gegenständlichen Entwurf findet das Thema aber in Wahrheit keine nennenswerte Berücksichtigung. Was es gibt, ist ein relativ lapidarer Verweis in Paragraph 9 des Sicherheits- und Nachrichtendienstegesetz auf die Strafprozessordnung, nämlich auf Paragraph 157, wo das Aussageverweigerungsrecht für Journalisten geregelt ist, ganz grundsätzlich, also für Medienmitarbeiter und Medieninhaber, und dass das auch nicht umgangen werden darf. Aber in Wahrheit passt das nicht zusammen. Weil einerseits haben wir das System der Strafprozessordnung, also der Strafverfolgung, und auf der anderen Seite hier in unserem Fall geht es um die Gefahrenforschung im Sicherheits- und Nachrichtendienstgesetz. Und diese Systeme sind grundverschieden. Gefahrenforschung erlaubt an sich einen aus grundrechtlicher Sicht größere Eingriffs- oder eine größere Eingriffsintensität als die Strafverfolgung. Und insofern stellt sich die Frage, wie das zusammengehen soll. Dazu kommt, dass wir in der Strafprozessordnung dann noch weitere Regeln haben, wie man umgeht damit, wenn Journalisten zum Beispiel selbstverdächtig sind. Der Verweis auf diese Bestimmungen fehlt völlig. Also wir haben keine Ahnung, wie man dann im Detail damit umgehen soll und wie man dann die Abwägung in diesem Bereich vortreffen würde. Also wir wissen das nicht, was das für eine Spielsoftware bedeutet. Dann wird in der Literatur auch kritisiert, dass dieses Redaktionsgeheimnis in der Strafprozessordnung vor allem freie Journalisten nicht ausreichend schützt. Das Problem hätten wir dann auch hier mit der Spähsoftware. Und was dann auch natürlich dazu kommt, ist, was ja eh schon besprochen wurde oder was ein allgemeineres Problem ist, dass wir ja technisch die Spähprogramme nicht auf bestimmte Kommunikationsvorgänge beschränken können. Das heißt, in Wahrheit ist da für potenzielle willkürliche Handlungen Tür und Tor geöffnet. Und wie wir schon gesehen haben beim spanischen Kollegen, passiert das ja auch tatsächlich. Und dann ist es natürlich auch noch völlig unklar, wie das Verhältnis jetzt vom Paragraph 31 Mediengesetz, wo dieses Redaktionsgeheimnis ja gelegt ist, zum Einsatz von Spähsoftware ist. Also auch das ist völlig unklar. Und zu diesen, sage ich mal, recht löchrigen Regelungen kommen dann noch ein paar grundsätzliche Probleme dazu, die das Problem aber noch verschärfen. Weil wir haben eben, wie gesagt, grundsätzlich haben wir in dem Entwurf eine Verhältnismäßigkeitsprüfung, ähm, die dann vorsieht im Einzelfall, ob eine Spähsoftware zum Einsatz kommen darf, also wo man dann die drohende Gefahr abwägt gegen die Schwere des Eingriffs. Und jetzt ist aber das Problem, dass für diese Verhältnismäßigkeitsprüfung überhaupt keine Vorgaben gemacht werden in dem Gesetz. Also es gibt überhaupt keine Richtschnur für die Entscheidung. Das Einzige, was es gibt, ist die Schwere des Delikts, also terroristische Straftaten und Spionagestraftaten, die mit einer Strafdrohung bis zu 10 Jahren oder ab 10 Jahren. Das ist das einzige Kriterium, das wirklich eine harte Währung ist. Und darüber hinaus wissen wir eigentlich nichts. Es geht um Betroffene. Wer sind Betroffene? Sind es Verdächtige? Sind es dringend Verdächtige? Sind es Zeugen? Ist das jemand, der jemanden kennt, der vielleicht verdächtig ist? Ist das jemand, der jemanden kennt, der Zeuge ist? Ist das jemand, der vielleicht zum Beispiel einmal eine Moschee besucht hat? Wir wissen es nicht. Also insofern ist auch das sehr, sehr problematisch, glaube ich, dass wir überhaupt keine Richtschnur haben für die Frage, wie letztlich die Entscheidung folgt, dass so etwas erlaubt wird. Und dann noch ein paar Wörter noch zu dem Verfahren, das diese Prüfung vornimmt und diesen Rechtsschutz eigentlich gewährleisten soll. Auch hier sehe ich einige Probleme. Zum einen, es ist natürlich ein mehrstufiges Kontrollverfahren vorgesehen, wo das Bundesverwaltungsgericht das entscheiden sollte unter Hinzuziehung des Rechtsschutzbeauftragten. Aber es sind Zweifel an der Effektivität dieses Verfahrens anzumelden. Der Rechtsschutzbeauftragte kann zwar eine Stellungnahme abgeben, dafür hat aber nur sehr, sehr eine kurze Frist von 3 Tagen und diese Stellungnahme hat keinerlei Bindungswirkung. Dann wird die Entscheidung vom Bundesverwaltungsgericht von Einzelrichtern getroffen. Eigentlich sollte das bei der Schwere dieser Strafdrohungen, die im Raum stehen, ein Kollegialorgan, also ein Drei-Richter-Senat sein. Dann möchte ich noch anmerken, also das nicht falsch zu verstehen, aber in der Literatur wird sehr, sehr häufig kritisiert, der gravierende Unterschied in der Richterausbildung zwischen Richtern in der Justiz und zwischen Richtern, die in der Verwaltung tätig sind. Also da genießen Richter in der Justiz eine wesentlich umfassendere Ausbildung, die vor allem auch richterliche Ethik berücksichtigt. Sowas gibt es bei Verwaltungsrichtern nicht. Und insofern wäre es wünschenswert, wenn es da eine richterliche Kontrolle gibt, dass das bei den normalen Gerichten liegt, wiewohl es da natürlich verfassungsrechtliche Gründe gibt in der Kompetenzverteilung, die möglicherweise hier entgegenstehen. Aber an sich hielte ich das für etwas beruhigender, wenn man in dem Zusammenhang von beruhigend sprechen kann. Und was dann die Ressourcen betrifft, die der Rechtsschutzbeauftragte braucht, um das leisten zu können, was man von ihm erwartet, steht da zwar im Gesetz, dass er die ausreichenden Ressourcen haben soll, aber wenn man sich überlegt, was dazu nötig ist, auch an technischen Kenntnissen, dann ist es zu bezweifeln, ob das tatsächlich in der Praxis so ausgestaltet sein wird. Und last but not least, was da auch noch dazu kommt, ist die Vertrauenswürdigkeitsprüfung, die sowohl die Richter des Bundesverwaltungsgerichts als auch der Rechtsschutzbeauftragte werden, um ihrer Aufgabe in dem Verfahren nachkommen zu können, vorab einer Vertrauenswürdigkeitsprüfung unterzogen. Und diese Vertrauenswürdigkeit prüft interessanterweise die Direktion des Staatsschutz- und Nachrichtendienstes, die dann die Richter und der Rechtsschutzbeauftragte ihrerseits überprüfen sollen. Also auch das ist ein potenzielles Einfallstor für potenzielle Abhängigkeiten und Loyalitätsbindungen. Also insofern ist das auch sehr, sehr problematisch, diese Ausgestaltung. Also insgesamt bleibt mal fürs Erste festzuhalten, dass das ganze System, wie das aufgesetzt ist, sehr, sehr löchrig, unausgewogen und unbefriedigend erscheint und wirklich gut schlafen. Wenn das so kommt, muss ich ehrlich gesagt sagen, nicht. Jetzt freue ich mich dann auf weitere Fragen und auf die weitere Diskussion später. Danke dabei.
Walter, thank you very much. This was extremely enlightening. And now to conclude, René, please.
Thank you. Thanks for setting this up and for this chance to again talk a little bit about the technical side. And maybe for context, I've been looking at Android security for quite a bit over 10 years, quite not so much on iOS security. I know that iOS and Android are sufficiently similar that what I'm going to say will mostly hold for both platforms. But I'm specifically still talking about Android because this is what I actually can speak about. I've had the privilege to even for 2 years lead the Android department, the Android group that does exactly those security measures. So for those, I can speak with confidence. And now when we think about the technical means of actually implementing what this law would like to enable for the DSN, then we first really have to look at what does this actually mean. And that's one of the slides that I show in my Android security course. And I think it illustrates that there is what we call sandboxing between Android apps. We have apps on Android, on iOS, they are actually contained within tight sandboxes. They cannot leave those sandboxes if they don't have permissions. So simply installing a normal application as you would do on, let's say, a Windows machine with administrative privileges is not enough to scan whatever content is within another sandbox on Android, within another app on Android. You have to break those sandboxes somehow. Those same sandboxes hold for work profiles. So specifically, people who hold confidential data on their phones, be that company employees, be that lawyers, be that journalists, they might use a work profile to further separate their business applications from their private applications. That's another distinction between those two, even using two separate sets of keys for the on-device disk encryption of that device. Then we have additional users. So shared devices could have different users. They again are separated from the main profiles. And all those separations, all those sandboxes are enforced by the Linux kernel, by the base part of the operating system. And that's not even all. In the newest releases, Android 14, 15, we see virtual machines coming in there for very critical workloads like on-device machine learning. That's even beneath what we consider to be the base operating system's kernel, where all those operations are separated from each other, where the sandboxes are technically enforced. And then even one layer deeper, we have the trust zone, etc., where the crypto keys for our logins for Digitales Amt in Austria, where all those things on the right side here are kept. This is actually where we have the cryptography that's separated on an even lower level. So with all those kinds of separations, what a spyware that we are talking about here does have to technically do is break through all those layers. So let's assume you get sent a message from one of the apps here at the top. You get a message through iMessage, through WhatsApp or whatnot, and that would be the trigger to break your device. It would first have to break the Android's kernel separation, then it might have to break into the VM separation to go, for example, into the learned data on the on-device keyboard, or it might have to even break the trust zone separation on the very deep chipset layer to break into the cryptographic keys that you might use for other apps, for example, accessing some cloud applications. This is extremely complex. So the first illusion that I think we have gotten past in a debate is that Austria would have the resources to write some of that attack software itself. I believe that even the DSN is no longer under the illusion that they could do that themselves, but they would have to buy it from some place else, that they would have to buy it from NSO or other companies who are specialized in making such attack software, breaking all those security measures that have been put into the technology for good reason. Now, the second illusion is that this can be technically controlled, because software that needs to be injected to break a target system needs to be small, needs to be nimble. There are many different versions of those target systems. So if you have an iOS device, maybe there are a few versions of different operating systems that this would have to work on. For Android devices, there's a wide variety. One single exploit that, by the way, on the black market goes for up to €1 million or more in terms of a single exploit. And typically you need more than one to break through all those security measures. So wasting a single one on a device that might get detected later on is something that people have to decide if they actually want to do. So there is a business model behind NSO and others that they would probably focus on those devices that are used by most users, not the niche devices, not the, I don't know, the fair phones, for example, that not so many people have. Maybe not a specific subset of devices used in a small criminal group. So the best way to avoid being attacked by such software is to use devices or device configurations that are uncommon, because that's not in the business model of a company like NSO to invest a lot of money to break those specific target devices. Which brings me to the next illusion, that this would actually work very well. So the illusion that you just enter a target phone number of whoever is actually maybe in a professional criminal circle and prepared with their own defense measures, that it would just work on the push of a button. Those security measures, they are updated, they're patched on a, let's say, monthly or even more regular cadence. The attack software has to keep up with those updates. So just thinking that you can attack any target device based on a phone number or email address is another illusion. It just does not work that well. That's marketing material, but not the reality. It works on an average number of devices, but maybe not on the specific target device that you want. And then we come to the next illusion, which is this complexity that goes into such attack software. The current law specifies that there is an evaluation period of 2 weeks for that software to be evaluated if it actually keeps within the line of what the law allows that software to do. So second illusion, would that be technically limited? No, that thing needs to break the security measures and exfiltrate all the data, and then the filtering on what kind of data is allowed in this specific one instance, what duration of messages could be filtered, that would be done on server side. It would never be done on the client device itself. So there's no technical limitation that would realistically be implemented on that attack software. It would just exfiltrate data and would then be filtered on the other side. But that complexity, trying to verify, even if you had all the source code of that attack software, which I doubt that NSO would give to Austria, having 2 weeks, there's no way that this could actually be checked. And that maybe brings me to the wrap up. We are on another level, we are having a debate about should Europe still trust F-35s or other US aircraft attack fighters. in comparison to what we're talking about, breaking software that is rapidly evolving, attack jet fighters are fairly simple. The pilot is still the one in charge. The Austrian pilot in the Austrian military still has the stick, still has the trigger to fire something. We are talking about, do they have a kill switch? Can the US government cause them to not be able to start? Here we are talking about buying extremely complex attack software, a software weapon from another non-European country that we really do not have any chance to know what it does and what it's going to be updated to do. We just have to trust that. So when we have to debate, do we want to have a foreign power control if our fighter planes can start? Here we should have the debate, do we want a foreign power to be able to control what we allow to be installed on our own people's phones? Thanks a lot. Happy to take any questions.
Thank you so much, Renee. And before we go to the Q&A, let me just do two more pieces of information. The parliamentary consultation on the draft legislation is still open until June 3rd of 2025. So there is still time to provide an opinion because the debate really matters. We believe that this is now a very crucial moment. It's a fifth attempt to legalize spyware in Austria. All previous 4 attempts failed. We hope this will be another one, but this is certainly up to all of us. And one way to also engage yourself in the debate is to go to the campaigning website www.bundestrojaner.at, where you find all of the informations. And with that, we're going to close the recording and go to the Q&A. Thank you very much.